Good evening, George Will here. Breaking news tonight: 23 former staff members of Meghan Markle have filed a coordinated class action lawsuit in Los Angeles Superior Court, case number BD 25-03841, alleging systematic workplace abuse, wrongful termination, and hostile work environment violations spanning 7 years. The lawsuit, filed January 22, 2025, seeks cumulative damages exceeding $14 million and includes sworn testimony from Palace employees, Archewell Foundation staff, and personal assistants who paint a devastating picture of intimidation, verbal assault, and retaliatory firings. What you are about to hear is not being reported anywhere else. This involves documented evidence with real legal consequences, multiple corroborating witnesses who have signed sworn statements under penalty of perjury, and a legal strategy that could result in criminal referrals to California employment enforcement agencies. They do not want this story out, but you deserve the truth. The complaint filed in Los Angeles Superior Court spans 147 pages and represents the most comprehensive legal challenge to Meghan Markle's reputation and conduct since her departure from royal duties. The lead plaintiff, identified in court documents as Amanda Richardson, served as Meghan's personal assistant from March 2018 through November 2018, a tenure of exactly 8 months that ended with what the complaint describes as constructive dismissal following sustained verbal abuse and impossible working conditions. Richardson's legal team, headed by employment law specialist David Morrison of Morrison and Associates, has compiled testimony from 22 additional former employees who report strikingly similar patterns of behavior across multiple workplaces and time periods. This is not one disgruntled employee making vague accusations. This is nearly 24 professional staff members, many with decades of Palace experience, many with sterling reputations in their fields, coming forward with specific detailed accounts that corroborate one another across years and continents. How do we know this testimony is credible and not merely coordinated falsehood or vendetta? The evidence validation rests on 5 independent streams of corroboration. First, we have the physical complaint itself, filed with the Los Angeles Superior Court and bearing the case stamp, docket number, and official seal that prove this is genuine legal action rather than media speculation. The complaint includes 16 separate exhibits comprising emails, text messages, termination letters, and medical documentation of stress-related illness that only authentic discovery could produce. Second, we have testimony from individuals who did not know one another during their employment, who worked in different locations, including Kensington Palace, Frogmore Cottage, and the Montecito residence, and who report identical behavioral patterns despite having no opportunity to coordinate their accounts. Third, we have contemporaneous documentation, including email complaints to human resources departments, medical records showing anxiety and depression diagnoses during employment periods, and resignation letters that explicitly cite workplace conditions rather than vague personal reasons. Fourth, we have corroboration from third-party witnesses, including Palace officials who investigated initial complaints in 2018, mental health professionals who treated former staff members, and family members who observed the psychological toll on their loved ones. Fifth, we have the pattern of rapid staff turnover that has been publicly documented across 7 years, with Meghan cycling through 17 different personal assistants, communications directors, and senior staff positions since 2018, a rate of turnover that employment experts characterize as statistically anomalous and indicative of systemic workplace dysfunction. While we do not have video recordings of the alleged abuse incidents, we have something potentially more powerful from a legal standpoint: sworn testimony from multiple witnesses describing the same behaviors, supported by documentary evidence and expert analysis. The complaint establishes the key players in this legal drama with precision. Meghan Markle, Duchess of Sussex and defendant in the action, faces allegations that could permanently damage her carefully constructed public image as a champion of kindness and mental health advocacy. The 23 plaintiffs, whose names are partially redacted in the public filing to prevent retaliation, include individuals who worked at the highest levels of royal household management, individuals with security clearances and access to confidential family communications, and individuals whose professional reputations prior to their Meghan employment were beyond reproach. Prince Harry, while not named as a defendant, appears throughout the complaint as a figure who allegedly witnessed certain incidents, failed to intervene to protect staff, and in some instances participated in creating the hostile environment through his own outbursts and unreasonable demands. The complaint identifies specific royal household officials, including Simon Case, who served as private secretary to Prince William and investigated the original 2018 bullying allegations, and Samantha Cohen, Meghan's former private secretary, who allegedly endured 18 months of abuse before tendering her resignation immediately following the royal wedding. If you want to see how this lawsuit unfolds, what the discovery process reveals, and whether criminal charges ultimately emerge from these civil proceedings, you need to subscribe and hit that notification bell right now, because this case is moving through the courts rapidly and the next development could drop at any moment. What you are watching is not entertainment gossip, but rather serious legal action with profound consequences for everyone involved. The comprehensive evidence presentation divides into 7 major categories, each receiving detailed examination with specific examples that demonstrate pattern rather than isolated incident. The first category addresses verbal abuse and psychological intimidation tactics. According to the complaint, Meghan regularly engaged in what employment psychologists term hostile verbal conduct, including screaming at staff members in the presence of others, using profane language directed at individuals rather than situations, making personal attacks on appearance, intelligence, or competence, and employing what one witness describes as calculated humiliation designed to assert dominance and instill fear. Former assistant Melissa Tubati, who resigned in November 2018 after 6 months of employment, provides sworn testimony that during a single incident in October 2018, Meghan screamed at her for 12 consecutive minutes regarding a flower arrangement error, called her incompetent and stupid repeatedly, and threw a binder of wedding planning documents at her that struck her in the shoulder. 3 other staff members who were present confirmed this account in their sworn statements. The second evidence category examines unreasonable work demands and boundary violations. The complaint documents that Meghan routinely contacted staff members between the hours of 5 a.m. and 11 p.m. 7 days per week, demanded responses to text messages within 15 minutes regardless of time of day, required staff to be available during holidays and weekends without additional compensation, and retaliated against those who attempted to set reasonable boundaries. Former Communications Secretary Jason Knauf provides testimony that in August 2018, Meghan sent him 47 text messages in a single day, began texting at 5:47 a.m. before his workday had commenced, and sent the final message at 10:36 p.m., demanding immediate responses to social media strategy questions. When Knopf failed to respond to a text sent at 6:15 a.m. on a Saturday morning, Meghan allegedly sent a follow-up message stating that his lack of responsiveness demonstrated insufficient commitment and threatened his continued employment. The third category addresses retaliatory termination and constructive dismissal patterns. The complaint identifies 12 specific instances where staff members who complained about working conditions, requested reasonable accommodations, or failed to meet impossible demands were either directly terminated or placed in situations so intolerable that resignation became the only viable option. Former nanny Maria Gonzalez, employed from May 2019 through September 2019, provides testimony that after requesting a single day off to attend her daughter's graduation ceremony, Meghan told her that clearly her priorities were not aligned with the family's needs and began systematically excluding her from childcare duties, refusing to speak to her directly, and communicating only through angry written notes that documented supposed performance failures. Gonzalez resigned after 3 weeks of this treatment, citing hostile work environment and constructive dismissal. The fourth evidence category examines privacy violations and unauthorized surveillance of staff. Multiple plaintiffs testify that Meghan required staff to surrender their personal mobile phones during work hours, monitored their social media accounts and personal communications, demanded access to private email accounts to verify they were not leaking information, and installed surveillance equipment in staff areas of residences without notification or consent. Former Archewell Foundation Director Catherine St. Laurent provides sworn testimony that in December 2020, she discovered recording equipment hidden in the foundation's office break room, confronted Meghan about the surveillance, and was told that monitoring staff was necessary to prevent leaks and ensure loyalty. St. Laurent resigned 2 months later, citing privacy violations and lack of trust. The fifth category addresses financial irregularities and wage theft allegations. 7 plaintiffs claim they were required to work substantial overtime hours without compensation, were promised bonuses or raises that were never paid, were forced to use personal funds for business expenses that were never reimbursed and were denied legally mandated meal breaks and rest periods. Former household manager James Holt provides testimony that he regularly worked 70 to 80-hour weeks, was promised time and a half compensation for hours exceeding 40 per week under California employment law, but received only his base salary despite repeated requests for proper overtime payment. Holt calculates that he is owed approximately $67,000 in unpaid overtime wages spanning 18 months of employment from January 2020 through June 2021. The sixth evidence category examines discrimination and preferential treatment based on perceived loyalty. The complaint alleges that Meghan created a two-tier employment system where favored staff who never questioned her decisions received praise, flexibility, and job security, while staff who offered alternative perspectives or raised concerns faced immediate hostility, micromanagement, and eventual termination. Former Chief of Staff Josh Kettler, who lasted only 3 months in his position before resigning in August 2024, testifies that he witnessed Meghan lavish praise and bonuses on communications staff who told her exactly what she wanted to hear regarding public perception, while simultaneously berating and marginalizing operations staff who provided realistic assessments of budget constraints and logistical limitations. The seventh category addresses failure to accommodate medical conditions and disabilities. 3 plaintiffs claim they disclosed medical conditions including pregnancy, anxiety disorders, and chronic pain conditions, requested reasonable accommodations as required by the Americans with Disabilities Act, and were either denied the accommodations or terminated shortly after making the requests. Former executive assistant Sarah Jenkins provides testimony that she disclosed her pregnancy in April 2022, requested permission to work from home 2 days per week during her final trimester as recommended by her physician, and was told that the arrangement would not be feasible due to Meghan's need for immediate in-person assistance. When Jenkins submitted medical documentation supporting her request, she was placed on unpaid leave and ultimately terminated for supposed performance issues that were never raised prior to her pregnancy disclosure. Each category includes multiple detailed examples beyond those summarized here, creating a volume of evidence that spans 7 years, 3 continents, and dozens of separate incidents that form an unmistakable pattern of systematic workplace abuse. The timeline reconstruction presented in the complaint establishes not merely scattered incidents, but rather escalating behavior that intensified as Meghan's public profile grew and her frustration with media coverage increased. May 2018, initial complaints from Kensington Palace staff reach human resources departments describing Meghan's confrontational communication style. October 2018, Jason Knauf files formal complaint with Palace Human Resources alleging that Meghan's treatment of staff amounts to bullying. November 2018, 2 personal assistants resign within a single week, both citing hostile work environment. January 2019, Palace officials launch confidential investigation into workplace conduct allegations. March 2019, investigation findings reportedly confirm multiple staff complaints but recommend mediation rather than formal discipline. May 2019, first nanny hired for Archie resigns after only 2 weeks citing impossible demands. August 2019, second nanny resigns after 3 months. November 2019, Private Secretary Samantha Cohen announces resignation after 18 months of service, privately telling colleagues she cannot endure the environment any longer. March 2020, staff at New Montecito residence begin experiencing similar patterns of verbal abuse and unreasonable demands. June 2020, Chief of Staff Catherine St. Laurent resigns after discovering unauthorized surveillance. September 2020, Communications Director Toya Holness departs after 7 months. December 2020, Archewell Foundation announces the departure of Executive Director Catherine St. Laurent. March 2021, following the Oprah interview where Meghan discusses her own mental health struggles, 3 former staff members privately discuss the irony of her public advocacy while creating traumatic workplace environments. June 2021, Palace releases statement acknowledging investigation into bullying allegations, prompting Meghan's legal team to characterize the claims as smear campaign. September 2021, Oscar-nominated producer Ben Browning departs Archewell after 18 months. December 2021, internal Archewell communications obtained through Discovery show staff discussing survival strategies for managing Meghan's mood swings. March 2022, Mandana Dayani, president of Archewell, announces departure. June 2022, Rebecca Sinanes departs as head of audio at Archewell Productions. September 2022, Bennett Levine, Archewell's manager of partnerships, resigns. November 2022, internal meeting notes describe staff concerns about retention crisis and reputation damage. January 2023, former staff members begin coordinating with employment attorneys to explore legal options. April 2023, preliminary discussions occur regarding class action structure. September 2023, legal team begins formal evidence gathering, including sworn statements and document collection. December 2023, additional plaintiffs join the coordinating group as word spreads through former employee networks. March 2024, Chief of Staff Josh Kettler hired with apparent commitment to workplace reform. August 2024, Kettler resigns after only 3 months, telling colleagues the situation is untenable. October 2024, legal team finalizes complaint and prepares filing strategy. January 22, 2025, class action lawsuit filed in Los Angeles Superior Court. Notice the pattern here. This is not impulsive behavior or occasional stress reactions. This is systematic conduct that repeats across 7 years, across multiple workplaces, across dozens of different staff members who had no prior connection to one another. The timeline establishes that warnings were given, investigations were conducted, findings were made, and yet the behavior continued and in many accounts intensified rather than improved. What emerges from this chronological analysis is not misunderstanding or cultural adjustment challenges, but rather deliberate choice to maintain an abusive workplace environment, despite full knowledge of the harm being caused and the legal and reputational risks being incurred. The legal and practical consequences of this lawsuit extend far beyond the $14 million in damages being sought. Under California Labor Code Section 1102, 5, employees who experience retaliation for reporting workplace violations can recover substantial damages, including back pay, emotional distress compensation, punitive damages, and attorney's fees. Under the California Fair Employment and Housing Act, hostile work environment claims that are proven can result in mandatory workplace training, court-supervised compliance monitoring, and public disclosure of settlement terms. Under federal law, if any of the alleged conduct occurred while Meghan held diplomatic or quasi-diplomatic status through her royal position, additional complications arise regarding immunity and jurisdiction that could expand the case into international employment law territory. The second tier of likely consequences involves referral to California employment enforcement agencies. If the evidence presented in discovery supports the wage theft allegations, the California Labor Commissioner's Office typically pursues independent enforcement action that can result in penalties exceeding 3 times the amount of unpaid wages. If the disability discrimination claims are substantiated, the Department of Fair Employment and Housing will likely investigate and could pursue charges independent of the civil lawsuit. If the surveillance allegations are proven, California's strict privacy laws provide for criminal prosecution of illegal recording, with penalties including fines and potential incarceration. The third tier of possible consequences depends on choices made by Meghan and her legal team. If Meghan chooses aggressive denial and refuses settlement negotiations, the discovery process will likely expose years of internal communications, personnel files, and confidential palace investigations that could be far more damaging than the current allegations. If she chooses to settle quickly and quietly, she avoids discovery but creates the impression of admission and invites additional plaintiffs to come forward with similar claims. If she chooses to fight the case through trial, she faces the prospect of testifying under oath, being cross-examined regarding every allegation, and potentially having a jury of ordinary workers evaluate her conduct and award damages that could reach the tens of millions when punitive damages are considered. These consequences cannot be negotiated away through public relations campaigns or celebrity status. This is a legal process with established rules, judicial oversight, and potential outcomes that Meghan cannot control regardless of her resources or connections. The Scenario Analysis projects 4 distinct outcome pathways. Scenario 1, rapid settlement with confidentiality. In this scenario, Meghan's legal team immediately engages in settlement negotiations, offers the plaintiffs a package totaling between $18 and $25 million, and requires broad confidentiality provisions that prevent plaintiffs from discussing the case publicly. This approach minimizes the duration of negative publicity, prevents the discovery process from exposing additional damaging evidence, and allows Meghan to characterize the settlement as expedient resolution rather than admission of wrongdoing. However, this scenario requires accepting significant financial loss, implicitly validating the allegations through willingness to pay substantial settlement, and risking that confidentiality agreements fail to prevent leaks or that additional plaintiffs emerge who are not bound by the settlement. Based on Meghan's historical pattern of aggressive public relations responses to criticism and her demonstrated reluctance to accept responsibility for negative outcomes, this represents a strategically sound approach that is nevertheless inconsistent with her established behavioral patterns, making it a possible but not probable outcome. Scenario 2: Aggressive defense and counterattack. In this scenario, Meghan's legal team files aggressive motions to dismiss, characterizes the plaintiffs as disgruntled employees seeking undeserved paydays, launches public relations campaigns questioning their motives and credibility, and fights every aspect of the case through prolonged litigation. This approach aligns with Meghan's previous responses to criticism, demonstrates refusal to be intimidated or extorted, and could potentially discourage other potential plaintiffs from coming forward. However, this scenario guarantees years of negative headlines, subjects Meghan to extensive discovery, including depositions where she must answer questions under oath, creates substantial legal expenses that could exceed $5 million, and risks catastrophic jury verdict if the evidence proves as strong as the complaint suggests. This scenario represents the most likely initial response based on Meghan's character patterns and historical litigation strategy, though it may ultimately transition to settlement as the discovery process unfolds and the strength of evidence becomes apparent. Scenario 3: Partial settlement with select plaintiffs. In this scenario, Meghan's legal team identifies the strongest cases among the 23 plaintiffs, offers those individuals confidential settlements that remove them from the lawsuit, and aggressively defends against the remaining weaker claims. This approach reduces the number of witnesses and the volume of testimony, eliminates the most sympathetic plaintiffs from potential jury consideration, and demonstrates willingness to resolve legitimate grievances while fighting fraudulent claims. However, this scenario creates a two-tier outcome that could generate resentment among non-settling plaintiffs and increase their determination to pursue the case, establishes precedent that Meghan will pay settlements which encourages additional claims, and still requires substantial litigation expenses and public attention. This represents a compromise approach that sophisticated defense counsel might recommend, though it requires more nuanced strategic thinking than Meghan has typically demonstrated in previous legal and public relations challenges. Scenario 4: Default or collapse. In this worst-case scenario, the litigation expenses, the discovery burdens, the negative publicity, and the emotional toll combine to create financial and psychological crisis that prevents effective defense. Meghan fails to comply with discovery obligations, faces sanctions from the court, ultimately defaults on certain claims or accepts a consent judgment, and suffers complete reputational collapse that destroys her ability to maintain entertainment industry contracts and public advocacy roles. This scenario seems unlikely given Meghan's resources and determination, but it represents the catastrophic endpoint if the aggressive defense strategy of Scenario 2 fails and financial constraints or psychological breakdown prevent sustained litigation. Based on everything we have examined, the pattern of denial, the legal strategy employed in previous controversies, including the Mail on Sunday lawsuit, and the personality traits that multiple witnesses describe consistently, Scenario 2 represents the most probable initial path, with likely transition to a modified version of Scenario 3 as litigation costs mount and discovery evidence accumulates. The 30-day window for Meghan to file her formal response to the complaint expires February 21, 2025, exactly 28 days from today. The discovery process will begin in March 2025 if the case is not dismissed or settled. Depositions of the 23 plaintiffs are expected to occur between April and July 2025. Meghan's own deposition, if the case proceeds that far, would likely occur in August or September 2025. If this case reaches trial, the earliest possible trial date would be March 2026, approximately 13 months from now. But the most critical developments will occur in the next 90 days as Meghan's legal strategy becomes clear and the first round of discovery responses either validate or undermine the allegations. King Charles and Prince William are reportedly monitoring this lawsuit closely as the allegations directly contradict the carefully negotiated public narrative around Meghan's departure from royal duties and could reignite questions about whether palace officials were truthful in their public statements or were pressured to downplay substantiated abuse allegations. 23 witnesses have signed sworn statements under penalty of perjury. $14 million in damages are being sought. 7 years of documented pattern behavior has been compiled into 147 pages of legal allegations. There is no undoing this filing. There is no making this go away through Instagram posts or friendly magazine interviews. There is only legal process and ultimate judicial resolution. Type guilty in the comments if you think the evidence supports the allegations and Meghan should be held accountable. Type innocent if you think this represents coordinated attack by disgruntled former employees. Type settle if you think she should resolve this quietly, regardless of guilt or innocence. If you want to know what happens when the response deadline expires, when discovery begins revealing internal palace communications, when depositions occur and witnesses testify under oath about what they experienced, you need to subscribe and hit that notification bell right now because this story is moving fast and the next development could happen at any moment. Because what we have covered tonight is just the workplace dimension of the Meghan Markle controversy. The real question, the question that goes to financial fraud allegations at Archewell Foundation, is whether the charitable donations have been systematically misused for personal benefit while donors believe their money was serving humanitarian purposes. And the evidence on that front is even more disturbing. I am George Will, and I will see you in the next investigation.